Number two, Section 173 does not give you authority to interfere with the functioning of the lower courts. And then number three, as per S versus Mulaudzi, the section ought to be cautiously applied. Otherwise, there will be chaos. It is precisely this type of jurisprudential chaos that we are being invited to do.
That's actually the discomfort that I have.
Yes.
If, for instance, I say I issue this order,
yes,
what will they say about the Constitutional Court orders?
Yes.
Because this is the apex court.
Yes, exactly. And once it has decided to be first and last, it's an extraordinary power. It has decided that no one else must hear the case, only us. And it has given an explicit order which is unambiguous. Mr. Zuma must go and present himself on Sunday. If he doesn't present himself on Sunday, tomorrow he must be arrested by the police. There is no ambiguity in that order. This is not up to a judge of a lower court. And your lordship would not be able to even interfere even if it had been issued by a judge lower than you. You wouldn't be able to interfere under Section 173. Then our learned friend says, well, I have another argument, Section 172, 1B. But again, let's start with the text. Section 172 says, powers of courts in constitutional matters. When deciding a constitutional matter, here is the key. Within its power, let's repeat that. When deciding a constitutional matter, within its power, a court may make an order that is just and equitable, including, and then it explains. In other words, justice and equity are not jurisdiction conferring attributes. The jurisdiction must pre-exist, because the section says if you are making an order within your power, you may have the following powers, the powers of regulation. So if jurisdiction is precluded by virtue of the nature of the order being a constitutional court order and a superior order, therefore, Section 172, 1B the pre-existing jurisdiction. Then, what are we left with in these arguments? We are left then with the argument that says a high court may, in certain instances where the exclusive jurisdiction of the constitutional court is engaged, issue an order on an interim basis. I found a judgment dealing with something similar to that. It's the United Democratic Movement versus President of the Republic of South Africa and others. It is cited at paragraph 14 of our heads of argument. But it is wholly misplaced, because that is not authority for the radical proposition that has been submitted by Mr. Zuma, or on behalf of Mr. Zuma, that you should suspend the judgment of the Constitutional Court. It simply says you can interdict Parliament because you have judicial authority over them, or you may interdict the legislature, the executive, from bringing into effect legislation that you want to challenge at a later stage, even if that challenge is on an exclusive basis. Say the president is about to release 1,000 prisoners on mercy or parole. Because it is the conduct of the president, only the Constitutional Court may deal with it. You may, in the interim, ask the High Court to interdict the president while you go to the Constitutional Court to challenge it. But it is not authority for the proposition that is being advanced today, which is this court must meddle. And the language of meddling comes from the SCA in Osthuizen versus RAF, must meddle with a judgment and an order of the Constitutional Court. To do so is to invite judicial chaos. Our learned friend is then left with the Pollack on jurisdiction, in which it is said, and my learned friend thankfully read this out for all of us, because it's very unclear from the copies that were circulated, but in which it is said that it does not matter where Part B lies. On Part A, the High Court would be entitled to issue an order. But stating that proposition illustrates precisely why it is completely irrelevant to what we are dealing with here. We are not dealing with who has jurisdiction for Part B. we are dealing with who has jurisdiction in respect of an order granted by the Constitutional Court. More narrowly, we are dealing with whether or not the High Court can suspend a period prescribed by the Constitutional Court. It is not a surprise that my learned friend, in his entire address, never once brought any authority that is on point and argued around the point. So, on those 4 reasons, it is quite plain that there is no jurisdiction to suspend a decision of the Constitutional Court. That jurisdiction belongs to the Constitutional Court. That takes me, my lord, to my next point, which is the issue of an alternative remedy. It is linked to jurisdiction, and I will explain in a second why it is linked to jurisdiction. But it is a separate ground to dismiss this application. Your Lordship knows the law. You may dismiss an interdict if there is an available adequate remedy. The remedy that is most obvious is approaching, and you asked my learned friend this question, is approaching the Constitutional Court for a variation. But our learned friends didn't do that. It is clear that the Constitutional Court has jurisdiction to vary its own orders. It has jurisdiction to suspend the enforcement of its own orders. It may do so in accordance with Rule 12 of the Constitutional Court rules, which specifically provide that if you bring an application under that rule as an urgent application, the Chief Justice may dispense with the forms and service provided for. In other words, the matter may be dealt with on an extraordinarily short basis. The Constitutional Court, and we did a full search of the instances where the court has suspended the periods provided for in its orders. We collated those at footnote number 4. We found Nduli, Silia, Teddy Betulik, ex parte Minister of Justice and Minister of Social Development. Collated those at footnote 4. I have no doubt that there are others. When you go through those judgments, what you find is instances where the Constitutional Court says Parliament has 2 years to pass legislation dealing with X. The 2 years is now up, and Parliament has not performed the legislative amendment. They go back to the Constitutional Court and say, guys, we're sorry. We cannot meet the deadline. Please extend the period in the order. And those are the type of examples where the Constitutional Court says, sorry, we will not allow you, or sometimes it says we will allow you. But in all of those judgments, it says we are relying on our power under Section 172(1)(b) or under Section 173. But it's always in the context of a pre-existing jurisdiction. So there is no question that the Constitutional Court has previously engaged with the power of altering the time periods contained in their own orders. And they derive their source, constitutional source, in Section 172(1)(b) and Section 173 of the Constitution. That is, in fact, the correct setting in which those sections may be engaged, not here. In the answering affidavit, Your Lordship pointed this out to my learned friend at paragraph 7, answering affidavit of the of Justice Zondo. We took the point there that the Constitutional Court could be approached because it has the power to vary its own orders. But in addition to that, we invited expressly the applicant to approach the Constitutional Court. You asked him the question also today, and what you have heard is that it was a choice they made. Mr. Zuma simply did not want to be litigating in 2 forums. So he deliberately chose not to go to the Constitutional Court and to put his eggs in the High Court basket. He must live with that choice, just like he must live with the choice of not opposing the earlier orders of the Constitutional Court. But quite apart from the fact that there is an alternative remedy that is plainly available to Mr. Zuma, There are very strong reasons why Mr. Zuma, in fact, ought to be running this litigation that has occupied us for today before the Constitutional Court. Let me list at least 6 of those reasons. Firstly, the 2 orders that we are dealing with, the January order and the June order, 28 January, 29 June, are orders of the Constitutional Court. Secondly, when the Constitutional Court granted the contempt order, 29 June, it weighed the public interest and it weighed Mr. Zuma's interest. It knew Mr. Zuma's age. It knew the conditions in the prison. It weighed all of those up and decided that he should nevertheless serve 15 years in prison.
15 months.
Sorry, 15 months in prison.
Yes,
15 months in prison. 15 years is the mandatory sentence for certain offenses, but this is a contempt. Nevertheless, decided that he should serve 15 months in prison. Thank you, my lord. Number 3, the rescission application is pending before the Constitutional Court. In fact, as Mr. Mpofu correctly points out, the Constitutional Court has elected to hear the case. Now, my learned friend says that they cannot set it down unless they know something about the merits. I would be very skeptical about that. My own experience of the Constitutional Court is that it is impossible to read them upfront, but I may well be wrong. Number 4, when the Constitutional Court set the matter down for the 12th of July, it knew that it had the power mero motu to suspend the execution. It has the power mero motu to suspend the execution. It knew precisely when the order has to be executed. It knew the date the police must arrest Mr. Zuma if he doesn't hand himself over. It knew the date when Mr. Zuma should hand himself over. But despite that knowledge, it decided not to use the mero motu power of suspending the operation. If Mr. Zuma applies to the Constitutional Court, who knows what their view is in the light of the submissions that he would make. But what we know for a fact is that the mero motu power of suspension was not utilized. Number 5, the Constitutional Court also knew that it would be a matter of days between the date of his arrest and the date of the hearing of the 12th of July. There is no way that they didn't know that we are hearing the case 3 days after the date we have ordered his arrest. And that if that was a factor, it would have been ventilated in their own order. And finally, it is manifest that the correct court to run the balancing exercise about harm versus the rule of law considerations, which are quite strong in the judgment of the Constitutional Court, is the Constitutional Court. The matter is before it. It is engaging with that matter on an expedited basis. Mr. Mpofu is right when he points out that they granted directions on a Saturday when they could have granted those directions on a Monday. But that's precisely the point. They are engaged with the matter on an expedited basis. And if Mr. Zuma wanted, he would have gone to the Constitutional Court and asked them for the extension or the removal of the period by which he should comply. So it would be wrong for this court